My name is Jing Huang. I'm an associate professor at the University of Sydney Law School. Today is International Children's Day. I think that if you have children in your home or you are children in your heart, today is a special event that we have a review, especially important that we join with our international experts to discuss how to protect the welfare of our children in the international or transnational context. So begin with start, let's acknowledge the traditional custodianship and the law of the country on which the University of Sydney campus stands. We pay our respects to those who have cared and continue to care for country. Okay, so let's have a gallery view. Today is indeed very excited. In the forthcoming 1 hour and 30 minutes, our internationally renowned experts will bring us actually travel around the world to look at the status quo, challenge, and the potential solutions to protect children in transnational and international contexts. And our first speaker will be Mr. Filippo Lotti. He's the co-head of the International Family and Child Protection Law Division at the Hague Conference on Private International Law, Permanent Bureau, and has more than 30 years experience in the field of child protection. And Filippo will discuss the international framework established by the Hague Convention. After Philip's presentation, we are going to look at Germany. Here, Professor Lucas Landmacher will present the most recent high-profile and controversial German constitutional case. So Professor Lucas Landmacher is a professor of private international law and comparative law in Kiel, Germany. He read law in Oxford and obtained a PhD in Congo or in Cologne. And then we are going to look at my colleague, Dr. Miranda Kay, the Australian situation. We know that Australia recently amended the Family Law Act, and very important, actually there is a high-profile case last December, actually right before the Christmas. Miranda is an academic in the Faculty of Law at the University of Technology Sydney in Australia and a member of Hague Mothers, a project aiming to end the injustice created by the Hague Child Abduction Convention. She also has experience in the Public Service Law Commission of England and Wales, and as a practicing solicitor, family law in the UK. So after we look at the Australian situation, and then we are going to look at the United States. We know that last year, the US Supreme Court decided an important case, Golden versus Seder. Miss Anna Maureen Coburn, who has practiced law and after 22 years of public service as a US Department of State Attorney Advisor for children's issues, as well as a USAID Regional Legal Advisor and Senior Advisor for children and youth in conflict. She has transitioned to practicing international family law with a focus on child rights cases and issues. So at the end, we are going to look at China. China hasn't ratified any Hague Conventions related to child protection, but China is a member state of the United Nations Convention for the Protection of the Child. Ms. Haitao Ye who is a lawyer at the Shanghai office of the Beijing Dachen Law Firm, specializing in marriage and family dispute resolution, family wealth inheritance and management. She is also a former experienced judge in civil and commercial trials at the Shanghai Pudong New District People's Court in China. So therefore, indeed, we are going to travel around the world. I'm going to divide this discussion into two parts. So the first part, before 7 o'clock, our speakers will do a presentation, and each speaker will have 10 minutes. And then around 7 o'clock, we are going to have 20 to 25 minutes as a panel discussion. If you have any questions at any time, please do not hesitate to put your question in the chat function. You can indicate which speakers you would like to answer your question, or you can just generally indicate your question, and our speakers will address your question. Okay, so now let me hand over the floor to Mr. Philip Lotti. Philip, the floor is yours.
Thank you very much, Jeanne, for your introductory words. You're welcome. Greetings to everybody on this very important day, the International Day of the Child. I'm really glad that we're able to meet on this occasion and to talk about this very important subject matter. So as Jeanne indicated, I'm from the Hague Conference on Private International Law. For those who are less familiar with the organization, we are an intergovernmental organization, which is based in The Hague, in the Netherlands. So that is an organization created by states, which budget is funded by states, and which work program is decided by states. The European Union is also a member of the organization since 2007. The Hague Conference mandate is to develop international treaties, conventions, which objective is to progressively unify the rules of private international law. We work in all areas of private international law, including children's rights, which is the object of today's presentation. In this area, we have, over the years, more than 130 years of experience, developed conventions on the general protection of children, on the recovery of child support, on the international child abduction of children, and intercountry adoption of children. All of these conventions implement in one way or another, the principle of the best interest of the child, which is found in Article 3 of the UNCRC. Those conventions, they all apply to all children, regardless of their background, the marital status of their parents, therefore respecting Article 2, which is the non-discrimination principle. And all of these conventions will, one way or another, safeguard the right of the child to be heard or to express their wishes, which is found under Article 12 of the UNCRC. I want to discuss three things, or present three matters today. One is the future of the parentage surrogacy project, very short. Then we will talk about the 1996 Child Protection Convention and the 2007 Child Support Convention. So for those of you who are following the work program of the organization, we have, this past March, members of the organization have actually adopted conclusions, recommendations as to the future work on parentage and surrogacy. So after more than 10 years of the organization working on a project with the assistance of a working group, the organization has now decided to move to an experts group. That is a group of experts made out of, a working group. We have moved to a working group made up of people representing their states who will be able to actually voice their views in relation to the laws and policies of their states at the meetings. The immediate mandate is to try to develop a single instrument that will apply to all children, if possible. If not, to look into a possible solution with 2 instruments. The working group is to meet on 2 occasions during the next year, once before the next meeting of the Council on General Affairs and 1 meeting afterwards. And in their work, the working group is to actually consider all the reports that have actually been developed over the years by the experts working group. So this is where we are, and they're to look into, of course, putting together private international law solutions to address the recognition of parentage across borders in all circumstances. So natural birth, but also including surrogacy. The next subject I would like to touch upon is the 1996 Child Protection Convention. I'm doing so in the light of what we will be discussing later today. That is that decision from the Supreme Court of the United States in Golan versus Sada. Important decision where there were discussions as to whether judges could provide for measures of protections upon return of children to their state habitual residence once abducted under the Child Abduction Convention. And the Supreme Court came down with the decision to the effect that judges in the USA have judicial discretion to order such measures, even though it may be not provided by the law or the International Convention, that is the Child Abduction Convention. If the USA were to become party to the 1996 Child Protection Convention, this would probably facilitate the issue because judges would then be in the position to order measures of protection under Article 11. These are measures of protection that can be ordered in urgent circumstances, and it is well understood in the practice under Article 11 that the return of a child further to an abduction is an urgent measure. And the beauty of this is that measures of protections ordered under Article 11 would be automatically recognized and enforced in the state where the child is to have a safe landing, but also in any other state through which the child would be actually going through traveling back to their state habitual residence. As long as these states are also parties to the 96 Convention, these measures would be recognized and enforced at the different steps of the travel back to the state of habitual residence. I'm also raising this. Australia as a party to the Convention of 96. All states in Europe are parties. The UK is also a party. Turkey is a party. We have a few states now parties in Latin America. And there would be quite a lot of benefits for the USA to become a party to this convention. It will allow them also to organize placements abroad where necessary under the convention. The convention would also help with dealing with unaccompanied and separated children because the convention covers this. And we've seen that the convention has been useful in this context in Europe in relation to the Ukraine crisis, where a lot of children have been traveling unaccompanied and separated. And the convention has proved to be a good source of solution to put measures of protections in place for these children while they're traveling. This 96 convention also alleviates the issue of undertakings, because this is how we work under the Child Abduction Convention, where you don't have the 96. Courts will ask the left behind parent they will order undertakings, which are extremely difficult to have recognized and enforced in the state of habitual residence when these undertakings are taken in the court that is actually tasked with the decision to return the child. My last point, very shortly, is about the Child Support Convention, and decided to actually touch upon this subject because Australia is not yet a party to the convention, where New Zealand is a party, the USA is a party, the whole of Europe is a party, the UK is a party. Canada has signed the convention, they're about to ratify it. And I thought it was a good opportunity to raise this possibility for those who are not aware. We have this new convention of 2007 in the area, which is extremely modern, which provides for the possibility to have applications and communications under the convention take place under secured communications over the internet. And we're working on systems for that effect. It's a brilliant convention where it actually put processes and procedures in place at a very lower cost in order to obtain as much child support back into the states concerned. So it's a convention, as we say at the conference, it's a win-win. It's good for children. It's also good for states because it makes certain that you actually implement your obligations under the UNCRC, that is Article 27, which provides that the payment of child support should be done by parents first, not states. So it also will help you alleviate some social welfare payments that you're making now as states, and it would actually make it possible for parents to actually contribute to the welfare of their children. So this is what I wanted to say in the 10 minutes I had. And I thank you very much for your attention and look forward for the question period. Thank you.
Thank you so much, Philip. Indeed, before this event, I discussed with my speakers that I look at the attendees, the profile of the attendees today. And I mentioned that unfortunately, we do not have many attendees from like ASEAN countries, like Asia. We do have quite a number of from Australia and New Zealand. So I think this is an event that we need to raise the attention, not only Australia, New Zealand, but also actually in Asia, the importance of the HCCH, Hague Conference of Private International Laws Convention. They have done a tremendously great job in this field. Thank you so much, Philip. And now let's move to Lucas. Lucas is going to talk about the super controversial, important constitutional case regarding girls. Lucas, now the floor is yours.
Hello, everyone, and thank you so much, Jean, for organizing our webinar and for the opportunity to speak to all of you today. The case I'm going to present to you features a common theme in the protection of minors. We can all agree that children deserve the highest standards of protection. But is there a point where our well-intentioned protective measures maybe go too far and actually disadvantage children? Exactly this is the balancing act which the German Constitutional Court was confronted with when rendering its decision on underage marriages. The court has declared unconstitutional parts of the German Act to Combat Child Marriages, a law that was passed in 2017 in reaction to the large number of refugees from the Middle East seeking asylum in Germany. According to the relevant provisions of German private international law, marriages celebrated under foreign law are voidable if one of the spouses was under the age of 18 at the time of marriage, and void if the spouses were under the age of 16. The court held that this latter provision violates the fundamental right of freedom of marriage under Article 6 of the German Constitution. This ruling, however, is in no sense an endorsement of underage marriage, as it has sometimes been misunderstood. Rather, the protection provided to children married underage has not been impaired by the decision. Instead, the key issue at hand was whether voidness of underage marriages in some cases could go too far, because it would take away rights that the person married underage otherwise had had. In the remaining 8.5 minutes, I would like to summarize briefly the factual and legal background of the case that led to the Constitutional Court's decision, then present the key reasoning of the court's decision, and finally outline the implications for the German legislator. The pivotal connecting factor in German private international law to determine the law applicable to the validity of a marriage is the spouse's nationality. Therefore, when a Syrian couple sought refuge in Germany in 2015, the starting point for a German court is to recognize the validity of the couple's marriage when it is valid under Syrian law. And that is even if the wife was 14 when the marriage was celebrated in Syria. Before the 2017 Act, however, the application of foreign marriage law had to withstand the concept of ordre public. German courts must not apply a foreign rule if that generated a result that is manifestly incompatible with fundamental principles of German law, in particular if it violated constitutional rights. And indeed, German courts generally held that underage marriages are incompatible with domestic public policy and therefore deemed them invalid. Ordre public, however, is a flexible concept which takes into account all particularities of a given case. In exceptional cases, therefore, courts considered underage marriages as valid, reflecting especially the trust that spouses had in the validity of their marriage and their wish to stay married. Indeed, there are couples who married underage but deliberately continued to live together for decades and raise children together, for example. The courts respected the spouse's will and left the validity of the marriage untouched in such exceptional circumstances. During the so-called refugee crisis of 2016, the topic of underage marriage attracted more general attention, which eventually caused the German legislature to pass the Act to Combat Child Marriage in 2017. Even the name of this act is quite remarkable, I might add. I will leave out many technical details, but the essence of the 2017 Act was that under German substantive family law, marriage can only be concluded in Germany when both spouses have reached the age of 18. More importantly, this age of consent is now also enforced on the level of private national law in cross-border cases. Marriages celebrated under foreign law are voidable if one of the spouses was under 18 at the time of marriage and void if they were under 16. The main consequence of the new rule was that the case-by-case approach within the framework of ordre public was no longer available to the family courts. Family courts could no longer take the individual circumstances of the case at hand into consideration. Instead, the legislator has stipulated a one-size-fits-all verdict on all and each and every underage marriage. Immediately, the 2017 Act drew heavy criticism, both from academia as well as from stakeholders concerned with the rights of women, children, and human rights. And it did not take long before this critical view gained judicial support. The case, which I mentioned before, of the Syrian couple, had in the meantime passed through the instances of the German judicial system, and in 2018 eventually reached the Federal Court of Justice, the highest instance in matters of family law. Since the 2017 Act meanwhile had entered into force, the Federal Court of Justice had to apply the new rules to the case. The judges, however, refused to do so actually, and instead referred the case to the Federal Constitutional Court to decide on the constitutionality of the provision, a procedure that is not invoked very often. The Federal Constitutional Court's decision, published only 2 months ago at the end of March, had been a long time coming. Generally speaking, the court shared the constitutional concerns that were brought forward before against the 2017 Act. The court began with finding that marriages entered into under foreign law are included in the scope of protection of the fundamental right of freedom of marriage under Article 6 of the German Constitution. In order to protect the freedom of marriage, the legislator may create rules that legally define and delimit marriage. In shaping these rules, however, the legislator must observe the essential structural principles of marriage, as well as the requirements of proportionality. The Federal Constitutional Court sees the legitimate aims of the 2017 Act in the creation of legal certainty and in the protection of minors, both with regard to the specific minors in a given case, as well as in, you could call it, general preventive terms in view of all married minors worldwide. The 2017 Act, so the court continues, was also suitable for achieving these goals. the minors concerned will be protected from the rights and obligations of marriage. Child marriages will be made more aware internationally as a harmful practice, and the clear age requirement will enhance legal certainty. The Federal Constitutional Court also approved the necessity of the 2017 Act. In particular, the court argued that the previously prevalent case-by-case approach would be less effective than automatic invalidity, since the marriage would remain effective until the court's decision became final. In this context, the court also referred to the United Nations Convention on the Rights of the Child and stated that the convention does not compel the contracting states to enact rules that require courts to review the circumstances of every single case. Ultimately, however, the Federal Constitutional Court declared the private international part of the 2017 Act unconstitutional based on a violation of the principle of proportionality due to the severity of the curtailment of the freedom of marriage. Indeed, the court emphasized the legislator's discretion, which allows for both setting age requirements for marriage and ordering the invalidity of underage marriages without examination of each individual case and the persons involved. Therefore, the court concludes, it is not the verdict of invalidity as such that is inappropriate, but the lack of rules on the consequences of an invalid marriage. In particular, the legislator must establish the possibility for the persons involved to affirm their marriage, either expressly or tacitly, once they are of age. Furthermore, the Federal Constitutional Court suggested to award maintenance claims to spouses whose marriage is invalid. Despite parts of the 2017 Act being incompatible with the Constitution, the court ordered its continued application until the entry into force of a new legislation, for which the court set the legislator a deadline for the 30th of June in 2024. Which options does the German legislator now have in light of the court's decision? The court seems to be in favor of a minimal solution, which merely cushions the rigid voidness of underage marriage and enables the couple to affirm the marriage. Yet, the decision could also be an opportunity for the legislator to go back to the previously practiced case-by-case approach. In the past, family courts were able to find adequate results for individual cases based on the specific circumstances of each case. Although the Federal Constitutional Court did not seem to prefer the solution, the legislator is certainly not prevented from taking this step. In the overall picture of our topic of private international law and the voices of children, the 2017 Act to Combat Child Marriages and the Federal Constitutional Court's decision remind us that the most rigid measure to protect children in private international law may not always necessarily align with the children's best interest. Thank you very much for your kind attention, and I look forward very much to your comments and questions in the roundtable session.
Thank you so much, Lucas. So actually in our roundtable sessions, we are going to discuss what does it mean by the best interest of the child. Now we are going to look at Australia. My colleague Miranda, we are going to present the status quo and the challenge of child production in private international law cases in Australia. Miranda, the floor is yours.
Thank you. I'm just going to share my screen. I hope that's working. Let me just go to slideshow.
Yes.
Yeah, perfect. I also want to acknowledge the traditional owners of the land from which I'm presenting, and that's the Gadigal people of the Eora Nation. I'd like to pay respect to elders past and present and any Aboriginal and Torres Strait Islander people on this webinar today. So I'm going to talk about the Australian changes that have been made in relation to the Hague abduction by the new government, which made promises. The Attorney General, before they came into office, made promises to make the Hague abduction safer for women and children. And I guess amazingly, the government has kept to its promises, well, most of them. So the convention was adopted in 1980. I'm sure most of you are aware, to deter international child abduction. And there are approximately 100 contracting states to the convention. It provides an expeditious method to return a child who's been taken by a parent from one member country to another. The idea is that children are returned subject to very limited exceptions, and any parenting decisions are made in the country of the child's habitual residence. So the welfare or best interests of the individual child are not the focus of Hague proceedings, despite that being the guiding principle in domestic family law in most contracting states. However, I think it's fair to say that the drafters did not contemplate that most taking parents would be their mother, who might be a victim of domestic violence. And so my talk today is just going to focus on cases where there are allegations of domestic violence. And I think we're looking at the unintended consequences of a convention where mothers are fleeing because they want to protect themselves and their children from violence. They often know that there'll be legal consequences of doing so, but maybe feel they have no choice. They either need to flee or lose their own life or the life of their child. Often they will have resources in the country to which they flee, both financial but also family resources, because it may be their original home country, but that is not always the case. So Gina Masterson has described 3 stages of abuse for these women and their children. And the first is the abuse in the relationship. The second is the abuse by the legal system in Hague matters. And the third is the abuse in the post-Hague environment. So once the child has been returned. And Gina and her colleagues interviewed women who discussed those harms, and they talk about the women being Hagued. And they talk about the harms upon return. Firstly, that not all women did return with their children that they interviewed due to fear that they would be killed and that the child would effectively be left with no parents. That the harms upon return for these women and children included violence, intimidation, control, financial abuse, homelessness, and separation from their children, despite them returning with the children because orders had been made in their absence for the father to have parenting orders, or having to share parenting with a violent ex-partner. Interestingly, from those interviews, almost all of the women eventually, and it took many years for many of them, eventually obtained full custody of the children and were allowed by the courts of habitual residence to return to the country to which they had originally fled, but only after enormous distress, abuse, and violence had occurred in the meantime. So the exceptions to the convention, the one that would be mainly be relevant for women and children who have been exposed to domestic violence is Article 13(1)(b). That is that there's a grave risk the child will be exposed to harm or otherwise placed in an intolerable situation. So research I recently carried out, this isn't just purely in Australian cases, looking at cases where mothers had fled to Australia due to domestic violence, found that in the 5 years to 2021, there was only one case in which a return order was refused, and that was upon appeal in a case called Walpole. So in other words, I think we found that the Australian courts are very likely to make an order for return of the child, to not find an exception based on grave risk to the child or of intolerable situation, despite allegations of some really serious violence in many of those cases. And it seemed to us that 4 decades of social science findings showing risk to children of being exposed to domestic violence are simply deemed irrelevant in Hague matters. So what happened in Australia was the government in December 2022, the new Australian Labor government introduced changes to the regulations that implement the convention in Australian domestic law. Because it's via regulations, it did not need to pass through Parliament, and the regulations actually take immediate effect. We do not yet have any court decisions on the regulations. I think they're a good start. I personally think the wording could be greatly improved in the regulation. I think in one, it says that the court may have regard to risk that the child might be exposed to family violence. Why that is not must, I really don't know. The equivalent in the Family Law Act would be that the court must have regard to family violence. Obviously, if it's not relevant, they don't have to have regard to it. I also have concerns that the way the wording is done is the courts may still emphasise returns with conditions rather than refusing returns. I'd prefer it if the wording said that the court must refuse to make an order for return if grave risk is established after considering family violence. And I'd love a clause that said the mere fact of the existence of protective measures in the country to which the child might be returned should not be considered sufficient to ameliorate the risk that the child would be subjected to or exposed to family violence. I think that's important because courts currently consider that co-signatory states have the capacity to adequately protect women and children upon return. This just ignores countless evidence, countless research, and particularly bodies from domestic violence death review teams. It's simply not true. The law cannot protect women and children. So another issue around the Hague Convention is in the past in Australia has been inequality of arms. It's very much, I think, a factor in many countries. So in Australia, the way the convention works is that the application is not actually brought by the left behind parents, it's brought by the central authority. And so there is no means test, there is no merits test, and the left behind parent has really expert lawyers who are employed by the central authority, and in most cases they actually appoint barristers for those to act on their behalf. Contrast the position of the taking parent, who's rarely awarded legal aid in Australia for Hague matters. Even if she does, many of those legal aid lawyers will not ever have done a Hague case before and will not know really what they're doing. We do not know how many women just consent to the child's return rather than pay for a lawyer, or rather than acting as a self-represented litigant. Upon return, the mother might find that the father has already secured parenting orders while she's busy defending the Hague matter. She might have used all her funds while he has spent none. The taxpayer in Australia has paid for his application. Seems to me this is a huge jurisdictional advantage, and it's another form of legal systems abuse, but this time by the system itself rather than by a perpetrator of violence. So, what's the Australian government done? Well, very recently we had a federal budget and the Treasurer announced $18.4 million to improve the safety of women and children in international child abduction cases. Look, I think this is fantastic news. You can look at the headline, the numbers there, but the one I want to talk about is the $7.4 million to introduce a financial assistance scheme, basically to try and have equivalent access to legal representation for both the taking parent and the respondent parent. We don't yet know how this is going to operate. The Hague Mothers Group are actually pushing for either the International Social Services or for women's legal centres to have this funding. I don't think that will happen. So we just do not know whether the lawyers will have the necessary domestic violence and Hague experience, but the promise of equivalent access is very welcome. So just to move on, I'm moving very quickly, the voice of the child, another exception is the voice of the child. I need to talk about it given that that's what we're talking about today. There is an exception to return based on the child's own exception. However, quite extraordinarily, I think, since 2000, Australia actually has wording in the regulations which is more onerous than the convention itself. I think we should at least change that wording back to the convention wording. Michelle Fernando has done a lot of research in Australia on this and says that it creates a high hurdle for children to meet before their objections can even be taken into account. It robs them of their voice in a situation where they have a right to be heard. Children are given no advice or information about what level of objection is required, and a strict application of the test, which quite often operates in Australian cases, leads to children being returned in contravention of their true objections and can cause harm. She believes there's a tension between the Australian regulations and the child's right to be heard under the UN Convention on the Rights of the Child. I think she's probably right. One way that children can try and get their voices before the court in Hague matters is for the appointment of an independent children's lawyer. That's in Australia, those are lawyers that act to represent the best interests of children. And until very recently, there was a requirement that they would only be appointed in Hague matters, where if it was there were exceptional circumstances. There's currently a bill going through Parliament. I have no reason to believe that this particular clause won't be passed, but who knows? Which will remove the requirement of exceptional circumstances so that children can be represented in Hague matters in the same way as they are in other family matters. Just very briefly going to talk about one case that was decided last year. I think it's something that we have not considered in Australia, and that's the position of First Nations children in The Hague. The family courts in Australia have made great improvements in relation to the consideration of Aboriginal and Torres Strait Islander child's right to culture in general parenting cases. Family law cases are certainly not perfect, but they're so much better than they were 20 years ago. But none of those improvements have yet translated into either Hague cases or amendments to the regulations. And I think this needs to be happening. We at least need to grapple with this issue in Hague cases. So you've got a case here with a First Nations child, a First Nations mother. The judge made the comment, I understand that the mother, who was an Aboriginal and Torres Strait Islander woman, would be genuinely concerned about the potential for the status of the child as a First Nations Australian to be underappreciated by courts in a foreign jurisdiction. It was actually a European court. However, that does not mean that sending the child back to Belgium will place them in an intolerable situation. And the case failed, the child was returned, the appeal failed, and the High Court also refused special leave to appeal. Look, I agree with the judge that the mother would be genuinely concerned, but I also feel that is such a massive understatement. The status of First Nations children is underappreciated by Australian courts, who should know better. So how can we expect European courts or courts of any other country to fully appreciate how a failure to consider a child's right to culture could be seen as a continuation of past policies and practices that cause extreme harm to generations of First Nations children? For First Nations children, the harm being considered directly relates to being removed from Australia because the connection to land is so crucial. So it's actually the return that is the harm. We need First Nations experts to consider how we can properly consider First Nations children. And my slides will be available after, so I've just put the references that I've mentioned in my talk. So thank you.
Thank you so much, Miranda. Now we are going to look at the United States. Anna Marie will discuss. Anna Marie will discuss a case decided by U.S. Supreme Court. Actually, present a very similar issue as Miranda just now discussed: the domestic violence and the very sad the conflict, the gender issues, etc. Anna Marie, now the floor is yours. I will display your slides.
Thank you. Can you hear me?
Yes. Okay, so let me just display your slides. Okay.
Hi, can you hear me?
Yes, yes.
Okay, thank you for confirming. So good morning, everyone, or good evening as the case may be. And thank you, Professor, for putting together the very helpful panel on International Children's Day. I would like to first speak to the context that is available concerning the recent Supreme Court case on the Hague Abduction Treaty. And go back to a little bit of what we mean by child participation under the Convention on the Rights of the Child. So I'm now on slide 2, and I want to stress that even though the United States hasn't ratified and is the only country that hasn't ratified the UN Convention on the Rights of the Child, even though we signed with intent to ratify, that it does provide very clearly for child participation in all proceedings for those parties who have ratified the treaty. And then it also talks about and I'm going to get to this as a factor in another forum that may be deciding cases under the Hague Abduction Treaty. There are 3 UNCRC optional protocols, and those protocols include children in armed conflict, as well as the one on the sale of children, child prostitution, and child pornography. There's also a relatively new optional protocol on a communications procedure, which offers those children in countries that are state parties to this protocol the right to go before the Committee on the Rights of the Child to bring a particular case involving themselves that violates any of those rights, in the CRC, including the right of participation. Then I wanted to, as Philippe gave a great overview of the important Hague Children's Conventions, I would just mention them. They include the Hague Abduction Convention, the Adoption Convention, the Family, the Child Support one, and also the Child Protection one. These, then we get to what I sense in all the speakers' presentations, and also sort of the evolution of child participation, is that we're really facing, on this very important celebration day, we're really facing questions of child participation in 2 areas. For example, many of the abduction cases that we're discussing, or even the child marriage one from Germany, deal with the individual case involving a child and whether or not they have the capacity or the age or the development or agency or representatives to represent them to speak and say their views in the particular case affecting them. But we're also seeing, especially under the CRC, that children's rights groups and children themselves are calling for more participation in the formation of the conventions and the implementation guidance that deals with them. In the US, we call this nothing for them without them. So instead of it being individual case calling for child participation or child views, as we often hear, we're looking at a broader systemic movement, frankly, to involve children in the creation of instruments, the implementation of instruments, and either directly themselves through their own advocacy groups or through civil society organizations or lawyers, frankly. So I just, let's see, I think we're on to slide 6 now, yeah. So just to reiterate, the CRC gives children the right to freely express their views and be heard. That's Article 12. All state parties have a legal obligation to fulfill and uphold those CRC indivisible rights, regardless of context, meaning regardless of whether you're applying a Hague Convention from the Hague Private International Law Organization. So then we also have this emerging movement of children being asked to their rights to be considered in all instruments, as well as their participation to be included in the ongoing evolution of conventions, treaties, and implementation guidance. The methods for child participation are really known to the UNCRC. So they have extensive country reports on the situation of children and youth that are periodically submitted, and advocacy groups, including children's advocacy groups, can participate in the what information the CRC committee gets. It also issues general comments on specific issues. It just recently issued one on climate issues and the environmental effects on children. And it also has issued a while back, but still important, a general comment on violence against children, because all violence against children, arguably including domestic violence against their mothers, violates the CRC. And we have seen an emerging jurisprudence where national courts apply both the CRC and the Hague Children's Conventions, including the Abduction or the Adoption Convention. This new communication protocol that I mentioned is only applicable when it's a direct petition by a child or their representative, as well as when the state party has signed the optional protocol on a communication procedure. These complaints, we have a couple hundred of them now. Some of them have dealt with the use of violence against children, but they've also dealt with asylum cases, immigration, deportations, child separation. But the few have addressed parental child abduction with the parent or the legal guardian seeking redress on behalf of the child. So one recent case was involved this protocol, and after the child was ordered returned to Spain by the Chilean court, the mother, on behalf of the child, petitioned the Committee on the Rights of the Child, and it issued an opinion ordering Chile not to immediately return the child to Spain, but to undertake some investigations about basically the best interest of the child. So you could see in this important opinion from the Convention on the Rights of the Child that the CRC, by having this new protocol, is providing inevitably another forum for questioning the decisions of a national court under either the Abduction Convention, but certainly this would apply to the other private law conventions that may affect particular children. So I wanted to mention that context because I do think it's important concurrently to understand that those developments are going on in the field of child participation. Now to the U.S. Recent Supreme Court, which I'll reiterate, the U.S. is not a state party to the CRC or to this optional protocol. But this Supreme Court case, which Judge Sotomayor wrote the majority opinion, was very interesting because it remanded a Hague child abduction case to basically to the district court to re-review an order of return for the child from U.S. to Italy in light of a finding of grave risk of harm to the child upon return. Upon remand, the district court nevertheless ordered the return of the child to Italy. However, one of the things that was interesting about this case, besides the remand to the district court to not necessarily return the child to Italy, was what the court said about undertakings or emulative measures. So Justice Sotomayor, writing for a unanimous Supreme Court, which some of you who follow our law may, be surprised at the unanimity of that decision, but nevertheless, that's what happened. She said on behalf of the court that when you're considering a Hague abduction case, it's not necessarily required to consider the mitigating measures that could be applied to reduce the grave risk of harm to the child. You could, but you weren't required. If you did, the three main factors for a court in exercising its discretion was to consider and prioritize, one, the child's psychological and physical safety, which looks like a best interest standard without the CRC and without the words best interest. Some of the factors that could be considered in the safety of the physical and psychological well-being of the child were if the risk is very grave, like sexual abuse, or if there is some evidence that the child, when returned, the protective measures or the parent won't follow any orders. The second criteria to be considered, if considered, was the role of the courts in addressing custody disputes and not encroaching on the role of the habitual residence court to make those custody disputes by going beyond what would permit safe return. And then the third criteria or factor that could be considered would be whether or not the mitigation measures and consideration of them would comply with the convention's requirement to act expeditiously. So that case, I asked myself and other practitioners, what difference would it make if the child's views were taken into account? In that case, there was not much talk of that. It involved violence against the mother, mainly, with some testimony about the effects on the child. The one that was before the CRC, the court had, the national court in Chile had taken into consideration the fact that the child had autism, the fact that the mother was the primary caretaker, and the child really only knew the mother's care in terms of dealing with this autism. However, it still returned the child to the habitual residence of Spain. That the CRC said that those factors were not adequately considered: the autism of the child, the need for protection for the mother, and the relationship with the mother to foster the child's growth and development and be in his best interest, were not properly considered by the Chilean court when it ordered the return of the child to Spain and to the father, who had a more limited relationship with the child. So I think we, as private lawyer practitioners or public law, international law practitioners, need to see that the intersection of these two areas of law is happening, and it's likely, as more state parties sign the optional protocol and communication procedures, it's more likely to happen. As a closing note, I just wanted to mention that separate from the legal frameworks, there are many practitioners who work in the field of child rights and child protection who see the SDGs, the Sustainable Development Goals, and particularly SDG 16, as opportunities to get more child participation into the programs, especially the laws and the policies, but also the programs that affect children. One thing I will mention is that under the SDGs, we have SDG 5.2, which is to eliminate all forms of violence against women and girls. We also have SDG 16.2, which is to end abuse, exploitation, trafficking, and all forms of violence against and torture of children by 2030. Because of these SDGs, we also have some indicators, right, that countries, including all countries which signed up to this, which includes the United States, they will have indicators to measure whether they're making progress towards these SDGs. And one of the indicators for the one against violence against children is 16.21, which says the proportion of children aged 1 to 17 who experience any physical punishment and or psychological aggression by caregivers in the past month. That's phrased so that it's not up or down. They just measure it, but of course the goal is to reduce the violence against children. I think I will conclude there, just with a more hopeful note that some of these trends, right, these in child participation, or leading to, a more forceful support for children's rights. For example, there's a recent WHO, UNICEF, Lancet Commission, those three entities, which are very powerful in both the child rights world, but also in public health initiatives, came out with a report and a new commission to advocate for children's participation in all countries for meeting the SDGs. And you will see they're using platforms now to get the views of children and child participation in the formation, not just in individual cases, but in the laws and policies and regulations that affect children. And we're also seeing more data on the effects of violence against children. For example, the Center for Disease Control has a very good survey. It's been taken in over 25 countries now, called the Violence Against Children Survey. And that is demonstrating by a household-based, population-based surveys that the violence against children in households is astronomical. And the UNICEF multi-indicator cluster surveys, which have historically measured household violence, are also contributing to the data showing violence against children. Not to mention that USAID historically has had the demographic health surveys, and they collect data on the status of children. And all these instruments, although they use different statistical methods, and they also occur on different schedules, the data is showing that the violence against children is a problem. So the grave harm risk to children, or the issue of what to do in cases involving child abductions that involve also violence that may be affecting a child, is part of a bigger problem, let's say, that in terms of the worldwide data and information on what is happening outside of the private law sector. So I will say that the groups that are working on this have, they've issued a lot of reports about things that can be done on a systemic issue, but they're also available for practitioners to use in cases that touch on the problem of violence against the mother or the child, and the effects, the psychological and detrimental effects that it may have on the best interests of the child. So thank you for this, and I look forward to the questions.
Thank you so much, Anna Marie. Now we are going to move to Hai Tao Ye, who is actually going to push further and going to discuss fetus, fetus, very young babies in terms of surrogacy arrangement. So Hai Tao, now the floor is yours. We can't hear you. You are muted. We can't. Yes.
That's okay. Happy Children's Day. This is Hai Tao Ye from Shanghai. Today, I'd like to share with you the topic, the protection of the children's civil rights in cross-border surrogacy under private international law. As we all know that with the rapid reproductive technology and the huge commercial interests in transnational surrogacy has become a common concern of the international society. We had to admit that transnational surrogacy is beneficial to human reproductive, but also it is beneficial to social stability to some extent. But meanwhile, it also brings a series of legal problems, especially the conflict of private international law and how to protect the civil rights of the surrogate children internationally. Let's start from this case, China's first custody dispute involving the foreign-related same-sex marriage and the surrogate children. Please see the PPT here. You can say Miss A and Miss B, both Chinese citizens. They got married in the United States. After marriage, Miss A conceived an embryo synthesized from Miss B's egg and the sperm provided by others, and gave birth to a girl in the United States. While Miss B conceived an embryo synthesized from her own egg and the sperm purchased, and gave birth to a son. Both the children were granted the American citizenship. In 2017, Miss A and Miss B settled back to China with these two children. In 2019, Miss B evicted Miss A from her residence on the grounds of emotional discord and hid the children. Miss A sued Miss B for custody and guardianship. She advocated that this case should be a foreign-related custody and guardianship case. So she proposed that the United States law should be applied first here. She requested the court to start the foreign law ascertainment. Now the case is on trial. This case is very typical, This case is very typical and involved many issues relating to the private international law. First, the effect of and domestic recognition of foreign same-sex marriage. Second, identification of personal relationship and property relationship between same-sex couples during cohabitation. 3, the legitimacy and validity of transnational surrogacy. 4, determination of parentage under transnational surrogacy. 5, foreign-related divorce. 6, guardianship. So you can see these questions not only covers the prerequisite issues, jurisdiction, but also application of law, especially question 3, 4, 6 relate directly to my topic today. Well, these conflicts arise from the following factors. First, conflict of international surrogate legislation. You can see there are countries that allows commercial surrogacy, such as Ukraine, Israel, and the United States. Also countries prohibit, such as China, Germany, and France. Some countries that have limited exemption, such as in New Zealand, the intended parents can only confirm their parentage from the legal adoption according to their domestic law. So the second conflict between the principle of meeting the best interests of the child in private international law and the principle of public order and good customs, or we see social public interests in domestic law. Third is conflicts of the lag between the relevant legislation and objective reality. So there's no uniform legislation we see on the surrogate children identification. Due to the conflict between the different domestic law of various countries that prohibit the commercial surrogacy, and those countries, they allowed commercial surrogacy. We see that the identification of the surrogate children, how to protect their civil rights, is rarely lead to some conflicts of the private international law. So we can see another case, that is the Ballas case in 2008. You can see it triggered a conflict of surrogate children's nationality identification between India and Germany. Germany parents had twins through the surrogacy in India. The Indian law allows the commercial surrogacy. So the Indian mother, we say the surrogate mother, has renounced her parental rights to the surrogate children when she signed the contract. So the twins cannot be granted the citizenship of India because they were born by a surrogate mother from India. While according to German law, the Germany does not allow the commercial surrogacy. So the children, they cannot obtain the Germany citizenship from their intended parents. I mean that the German law does not recognize the relationship between the intended parents and their surrogate children. So that will leave us some questions. How the children get their nationality? India, Germany, then really at last, these two children were granted German citizenship because they were adopted by German parents according to German law after 2 years hardship. So from this case, we can see that usually due to stateless, the surrogate children are always in vacuum zone. they cannot obtain the identification like the normal children. But meanwhile, they can also not get the protection from the country of nationality. So they are not entitled to the welfare treatment and the equal opportunity of education. Frankly speaking, I personally do not agree to fully liberalize the transnational surrogacy, because this will allow the intermediaries, medical institutions, and the personnel who take advantage of the surrogacy and exploit the huge commercial profit space. And what's more, I think they will trigger those kind of moral risks and the legal risks, such as child abusement, child abandonment, and so on. In other words, we are not ready. So, however, I believe that the international community can further regulate those conflicts of private international law of transnational surrogacy with joint efforts from the following aspects, so that the children's interests and the rights cannot be seriously infringed, and the conflict of the private international law can also be better resolved. So you can say, at first, we can try to establish the basic rules of private international law for conflict resolution. For example, the principles advocated by CERC for the best interests of the children, and the genetic link principle. Second, to establish international department and the national central agencies for necessary record review and regulation of transnational surrogacy, even in countries that allow commercial surrogacy. Those intended parents need to get improvement, register the record at first for surrogacy. The legal effect of the surrogacy can be recognized. In those countries which not allow the commercial surrogacy, for the children, those children already born, how to protect their civil rights, I think this needs to be coordinated by the international department through the legal adoption convention by reference. Third, to strengthen international cooperation and strictly crack down the transnational crime against the surrogate children, just like what I mentioned before, the abusement of the child, selling and buying children, and also the abandonment of the children. And at last, to strengthen unified legislation of private international law. As we all know, when time is right, I think a private international law specifically regulating transnational surrogacy should be formulated and adopted according to many of the scholars in response to the call of the overwhelming majority of the scholars, so as to protect those rights and the interests of the surrogate children. So every coin has its two sides. With the rapid development of the life science and reproductive technology, I think people's desire for reproduction and their needs cannot be ignored. With the joint efforts of all of us here, I think we will do something to greatly reduce the influence of the conflict of the international private law about the transnational surrogacy. Thank you very much.
Thank you. Thank you so much, Haitao. Thank you so much for all the speakers for your wonderful presentation. In our roundtable section, we are going to actually focus on the core issue of children's protection. So today we talk about the voices of children, but the children, they are minors, right? So how can we determine their best interest? So I guess, let me go to Haitao first, because you mentioned that there are 4 solutions. The first one, actually, we need to decide our cases, or we make our arrangements, or the countries that negotiate the treaties for the best interest of the children. But how to determine the best of the interest of children in China?
My pleasure. Actually, Chinese government attaches much importance or great importance to the protection of the children's interest and their rights protection. For example, in a divorce appeal case held in Shanghai #2 Intermediate People's Court, a German father and a Chinese mother, they battled fiercely about the custody of their children. Well, finally, the first instance wrote the principle for the best interests of the children of the convention into the judgment and held that clearly they should take the principle for the best interests of the child in the convention for the primary consideration. Actually, it held that every state party shall ensure those children enjoy the equal rights listed in the convention within their jurisdiction and without any distinction on the basis of their race, color, and so on. So finally, the court took the following factors into their consideration. For example, the living environment of the children, the education environment of the children, the income of their parents, the nationality of the children, and the best care that children can receive from which party, and finally draw the judgment. So this verdict also be upheld by the second instance. I think this case can reflect the attention of the court and the implementation of the principle for the best interest of the right of the children in the convention in Chinese judicial practice. Thank you.
Thank you so much, Haitao. Now let's go to Anna Marie. We know that although United States hasn't ratified the CRC, the United Nations Convention, but actually United States has ratified many other conventions related to children's protection. So especially this year is the 30th anniversary of the Hague Convention on Inter-Country Adoptions. So can you briefly talk about in United States, how the court will determine the best interest of the children under this convention? Thank you.
Thank you so much. I'm just checking to make sure you can hear me.
Yes,
No?
yes.
Yeah, okay, thank you. So it's a good question. I believe that the intersection of private international law, children's conventions, right, and the U.S. failure, frankly, to ratify the CRC is going to get more and more problematic, right? As the private international law sector genuflects to the child's best interest and to the principle of child participation, but without the concurrent CRC treaty or the new optional protocol, it is less likely for the US courts to be able to refer at a federal level to the child's best interest as well as to the child's right of participation. Even though in most state courts, we have child protection principles being interpreted similar to the CRC, right? Most of our statutory law, state by state, would say that the child's best interest should be primary. It wouldn't necessarily give a right of child protection communication or participation unless that was defined in statute. The problem with that, at least for the US, right, is that the child's voices don't get heard. And in my view, best interest, like you were saying, is hard to determine. It's a very big general principle. But the views of the child, particularly if they have advocates, lawyers, or child rights organizations to investigate, maybe a guardian, but those views of the child will infuse the right of the child to be his or her or their best interest to be taken into consideration. I think for the Adoption Convention, which has historically been a very important convention for child protection, oftentimes the voices of the children are not heard, particularly the voices of the children who are prohibited from being adopted because their country as a state party decides that they don't have Hague compliant procedures. So there's no adoptions from that country. That tends to avoid dealing with the voices of the child who are lacking in permanent family placement. I also think historically we have not heard from the voices of adoptees in the formation of the treaty, particularly as to their rights about getting information on their family of origin, getting medical information, as well as post-adoption services. So in those two contexts on that treaty, there's room for improvement so that child participation actually infuses better implementation of the treaty.
Thank you so much, Anna Marie. Now let's look at Australia. So Miranda, when we look at the best interest of children, I understand that you do a lot of research actually involving females, parents, moms. So, what do you think of Australian court and legislator? What advice would you give to Australian court and legislator?
Well, there's a huge difference, isn't there, between family court cases where the best interest of the child is paramount, and then in Hague matters where the whole real premise of the Hague is that the best interest of the child will not be determined in Australia if that's the deciding court, and it will be in the court of habitual residence. And the idea is that the best interest of the child kind of as a group will be improved by preventing abductions. I have real concern that even systemically, the best interests of the child in Hague matters are not being met in cases of domestic violence. That's my concern. Yeah.
So thank you so much, Miranda. Now let's look at Germany. And Lucas, I understand that the German constitutional court cases actually implicate the refugee issues. So in your point of view, how does the legal situation in Germany compare to that of other European jurisdictions, especially when you have so many migrants or refugees, especially we consider the best of interest of children, in this case, actually it's the girl. Yeah, so here it also related to Miranda's point regarding the gender's perspective. Thank you.
Thank you for the interesting question. Well, I agree that in most cases it will be girls who will be on the end of having been discriminated against in this group of cases, but it's not necessarily always the case. We also know of cases where both of the spouses were 14 or 15 when they married. So it's not always the girls, but as you said, in most cases. Regarding the other aspect of your question and the comparative perspective of underage marriages in Europe, and as you correctly said, the issue of migration from countries from the Middle East is not only an issue in Germany, but in many other European jurisdictions. And in fact, we see that in many jurisdictions over the last 15 years, rules were introduced, laws were passed, which brought stricter laws regarding child marriages, which was celebrated under foreign law. We have examples in France, in the Netherlands, in the Scandinavian countries. But if you look at those jurisdictions, they tend to have more flexible approaches, less rigid approaches than Germany. They are more open to the idea of underage marriage in a way. So, and interestingly, the German Constitutional Court took those other solutions into consideration when rendering its judgment. So, in fact, the court received guidance from the Max Planck Institute, which prepared a huge report on the legal situation in many jurisdictions. And the Federal Constitutional Court drew from this expert opinion and integrated those insights into the decision. So it actually produced a little bit of comparative legal work, and to show that the German solution is in a way an outlier in Europe. And that's why it was an even more compelling reason to consider the Act of 2017 as unconstitutional.
Thank you so much, Lucas. Now, after we look at the national courts and national legislator, national practices, we finally go back to Philip. Hague Conference on Private International Law can be considered as the global custodians of developing children-related international conventions. So Philip, now the floor is yours. Regarding the best interest of children, from the United Nations Convention, and then has been inherited by all the Hague Conference conventions. So do you have any suggestions, how the member states and their courts, their legislator can do better?
Yes, thank you very much, Jan, for your question. Look, I've talked about the Child Protection Convention and child support already, and the UNCRC provisions that they implement. The Adoption Convention, Anna-Marie touched upon, it does implement the subsidiary principle, so that's quite important. What I'll say a few words more on the Child Abduction Convention, on which Miranda just spoke. And to start to say that I completely agree with her, that it is in the best interest of children that they are not wrongfully removed or retained across borders. It's not good for children to be taken out of their roots, their habitual residence, their family, their friends, school activities, and so on. This is extremely disruptive. And the UNCRC invites states to actually combat this by becoming parties to existing instruments. And this is what the Child Abduction Convention is about. Now, to go to that convention more specifically, yes, it is to combat this, but this convention is also to protect contact rights and access of children. And that is also in line with the UN Convention on the Rights of the Child. Article 9 and 10 provide that a child has the right to have contacts with both parents, except in exceptional circumstances. So what is this about in relation to the Child Abduction Convention? It's very simple. A parent on their own cannot change that right of the child to have contact with both parents without the agreement of the other parent. So that is really the fundamental, the rule of law of contacts. You cannot change a contact on your own. You have to have the agreement of the other one. So the convention should force people, instead of wrongfully, taking children or retaining them, should force parents to agree where there are difficulties, where there are problems. And I completely understand under DV family violence, it's really difficult. But then if parents cannot agree between themselves or have mediation, they should go to court instead of, retaining a child abroad or removing the child abroad and then have courts abroad. And no, they should try to have these matters settled in the state where they are. And then I will agree to another point that Miranda Kay has put into her PowerPoint. I mean, at the core of this is, and this is your question, what states can do to actually, improve the situation? Well, they should put in place solutions, systems to prevent domestic violence, family violence, to provide solutions to resolve these issues when they happen. And look, personally speaking, I think it starts at school. We have to learn to actually, discuss our differences, to address our different views, to address our disputes in an amicable way by speaking, telling people, you're doing this, I don't like it for the following reason, it's affected me, don't do this again. I mean, people have to, it's in some families it happens, but schools have a role as well in educating children to make us better adults later, better parents, and to address these issues. At the very core of domestic violence, family violence, very often is a toxic relationship. Why do toxic relationships develop? Very often, it's also questions of communications. Coaching is also a possibility for people to try to resolve these issues. It's not just about law, but it's also about trying to understand each other, to work better together, and these things. Anyway, it's a very short period of time. I'm giving you a very short glimpse. Of course, the problem is a lot bigger. There's a lot of more issues. I'm trying to make it simple here, but what I'm saying here probably covers 50, 60, or 70% of the cases. And if we can resolve those, I think it would be a good step in the right direction. Thank you.
Thank you so much, Philip. Thank you for everybody, including our participants. On this special Children's Day for Australia, now it's at night. For Europe, at The Hague, it's the beginning of the day. So I strongly suggest you to spend some time with your children, or if you are children in your heart, maybe go to watch a movie, to have an ice cream. We need to really work together to join hands and to safeguard the children's rights. They are the future of our country, our globe. Okay, have a great day. Bye-bye. Bye-bye.
Thank you.
Thank you. Bye-bye.
Thank
Bye-bye.
you.
Bye-bye. Bye-bye.